So you're an artist or a creative, and you've heard whispers of this mythical EB-1A visa or green card category. Well, navigating the EB-1A process can be daunting, especially for artists or creatives. I'm here to help. Understanding the specific requirements is a key to success. I'm here to break down the EB-1A requirements, focusing on the 10 regulatory criteria. And I'm here to identify a common pitfall that a lot of artists or creatives run into. But first, let me introduce myself. I'm Stefan Akorli, an immigration attorney, and I'm here to do for you what so many people have done for me over the years, and that is to provide important information that could maybe change a life or two. Now, if you're feeling like you're already losing your mind, or simply want someone else to handle all this immigration law madness, or have a unique situation, or just want to move speedily, my contact information is in the description. Let's start with this. What is the EB-1A visa or green card? You want the gist? Fine. EB-1A, you. Top of your game? Prove it and keep working in your field. Not permanent residence on approval of only the EB-1A petition, but it's a fast track if your history is clean. No employer needed. That's the gist. If that was too short, don't worry, I'll ramble later on. USCIS measures extraordinary ability with a checklist. In part, there are two parts of the extraordinary ability analysis. In the first part, unless you've received a major award like a Pulitzer, an Oscar, an Emmy, a Tony, then USCIS presents 10 criteria. These, 3 of which you need to satisfy. Then, in the second part, they decide if you're really that good. But you only get to the second part if you pass the first part. Artists, a diverse bunch. Yet I generalize. 10 criteria, they're hoops. Let's see which most kinds of artists can jump through. Evidence of receipt of lesser nationally or internationally recognized prizes or awards for excellence. Artists do win prizes and awards, but to qualify, an artist must 1. Receive a prize or award, 2. That has national or international recognition, 3. That is awarded for excellence, 4. In their field. All 4 elements are required. Often, people have difficulty showing that their prize or award has national or international recognition in their field. Group awards, they're acceptable in some cases. Evidence of your membership in associations in the field which demand outstanding achievement of their members. Artists often skip this one. Evidence of published material about you in professional or major trade publications or other major media. Artists take note. Press coverage is useful, but establishing that it is major and about you is where people get stuck. Still, it's not uncommon for artists to receive press coverage that would, with the right presentation of the right evidence, qualify here. Evidence that you've been asked to judge the work of others, either individually or on a panel. Judging. Some artists do it, particularly those working in an academic setting or in certain fields such as dance. Here, you have to show that 1. You received the invitation to judge the work of others, and 2. You actually did judge. The tricky part for some artists is documenting the actual judging. Evidence of your original scientific, scholarly, artistic, athletic, or business-related contributions of major significance to the field. Applicable to artists. This one refers to artistic contributions. The tricky part here is making the case for your contributions' major significance in your field. Your art matters to you, but major significance in your field, that's another ballgame. And it's a game with a surprising lack of clear rules for non-lawyers. For instance, significance is a word that's undefined by the statute or regulations or USCIS policy. Evidence of your authorship of scholarly articles in professional or major trade publications or other major media. Artists often skip this one. Evidence that your work has been displayed at artistic exhibitions or showcases. Artistic exhibitions or showcases. Obvious for artists. Evidence of your performance of a leading or critical role in distinguished organizations. Applicable to some kinds of artists. Think of a member of a band. But artists often skip this one. Evidence that you command a high salary or other significantly high remuneration in relation to others in the field. Applicable to artists. Though this criterion is not as straightforward as it might seem. For instance, many artists without a lawyer have trouble adequately establishing the salary or remuneration to compare theirs to. Evidence of your commercial successes in the performing arts. Commercial success, performing arts, definitely applicable to some artists. We've gone through all 10 criteria, but there's something else. Comparable evidence. If a criterion doesn't fit, prove it. And then you can submit evidence that is of comparable significance to replace that criteria. But you also have to prove that what you've submitted is of comparable significance. Comparable evidence, it's a great underused option. After you met 3 of 10 criteria, you go to part 2 of the analysis, where you must demonstrate 2 things, one of which is sustained national or international acclaim. Now, sustained does not imply that someone very early in their career does not have a case. However, it does imply that someone who won a Grammy in 2015 and then became hermit-like would likely have a difficult case. The second thing you need to show in this second part of the analysis is that you are among the small percentage at the top of your field. At the top, sustained national or international acclaim. These requirements can present a, challenge for many artists. And yes, my explanation of the second part of the extraordinary ability analysis was, shall we say, concise. But if you're one of these artists wondering about your chances to satisfy all the requirements, or if you just want to complain, my contact information is below. Contact me. Admittedly, satisfying these requirements, the part 1 and part 2 requirements, are not the only challenges for artists. Let me bring your attention to the O1 visa artist trap. In case you're unaware, the O1 visa is a non-immigrant, that is temporary visa for people who have extraordinary ability in the arts, among other fields. What happens is an artist gets multiple O1 visas and then petitions for the EB-1A and then denied. USCIS denies their petition. But O1 visa holders in the arts think the US government, USCIS, is already determined that I have extraordinary ability. But while it's true that the phrase extraordinary ability pops up in the O1 and the EB-1A category, it doesn't mean the same thing. Proving extraordinary ability for an O1 as an artist is much easier than proving extraordinary ability for an EB-1A. Receiving an O1 as an artist is not remotely determinative of your eligibility for an EB-1A. Getting an O1 visa does signal that you're impressive, but it does not imply that you'll have an easy road to an EB-1A. Now, if you're staring at a blank Word document when you're working on your EB-1A, or you have a unique situation, or are aiming for a swift process, or are simply seeking expert legal guidance from start to finish, write to me. My law firm can help. Contact information is in the description. You've endured this entire video. Congratulations. Now subscribe. More of this is coming.